Welcome to Jurisprudence by Jenn. I am Jennifer Dickwist, and I'm an attorney here in the Commonwealth of Pennsylvania. I currently own my own law firm, JD Law, where I focus my practice in the areas of family law and general civil law. This is the second video in a series looking at the 16 custody factors a judge considers when evaluating a custody case. So if you missed the first video, please make sure to look on our YouTube channel and go back and find it. You'll also find my official introduction and details about my resume within that first video. This week, we will be discussing the second factor in a custody determination. As always, I have to put out my disclaimer that I am not allowed to provide legal advice specific to your case in these videos, but I am going to go over general information regarding the law and regarding the statutes that are currently in place. If you do have a legal question or a legal concern, or if you need more information pertaining to your individual case or a case that you think may be happening in the future, please contact me by phone at 412-295-8066 or email at jennifer@jdlawpa.com, and we can go over all the specifics of your case and hopefully get you some solid legal advice. So the second factor a judge is going to consider when determining a custody case is whether there is a past or present abuse committed by one of the parties or a member of their household or extended family. This also includes whether a child has been seen by Child Protective Services and whether Child Protective Services are involved with the family at this time. The goal of this factor is to take into account the risk of harm to the child from the past and the risk of harm that is potentially there in the future. We then weigh these two risks against each other. The weight given to this factor may be different if a parent is currently abusing the child versus a family member who abused the child in the past and no longer lives anywhere near the child. So this is a factor that a judge can weigh very, very heavily, or it can be a non-issue in your case. It just depends on the circumstances, again, surrounding the facts of your case and what's currently happening. So to begin with the most obvious, if physical abuse is still present by one of the parents, then it may not lead to the judge recommending regular visitation, but it may lead to the judge recommending supervised visits. It also could lead to further investigation by Child Protective Services. Each county in Pennsylvania and each state refers to this agency differently. Some of you may know it as Child Family Services or Child Youth and Services, or maybe just Child Protective Services, depending on where you are. All of them are the same. They have a similar function. It just depends on where you live. Supervised visits may be advised in these types of cases where abusive parents can only have custody in the presence of another party. This could be a supervisor from within the family, or if that isn't appropriate, then it could be supervised either via probation or the local sheriff's office. So you could potentially have child custody time where a sheriff follows you to your custody visit. Here in Allegheny County in Pittsburgh, we also have a nonprofit organization that has supervised visit time at their location. They are short, brief visits. There is a playroom, there is space to have private time, but again, it's completely supervised, it's videotaped, and the court likes to use that in a last case scenario. If there's been past abuse and a child is still seeming unwilling to go with the parent, specifically the one that was abusive, the judge may rule that the parent and the child will have to attend supervised reunification counseling. Reunification counseling is with a certified therapist. We have court-appointed therapists here in Allegheny County. It may be different where you live, but generally there is some relationship between the court and these therapists. And this type of therapy is designed to provide a safe space where a child can express the reasons why they do not want to go with the parent, and it allows the parent to respond. And the child and parent can then work on their relationship, and the reunification counselor can provide reports to the court over time. As the reports come in, as reunification counseling proceeds and supervised visits proceed, the judge may increase visitation time for that parent and eventually allow for regular custody time that we would see in any other custody case. When it comes to addressing mental abuse, this is a completely different side of the coin. It is very difficult to show that mental abuse is happening in a household. It's also very difficult to show without looking like you're attacking the other party. You have to have tangible proof of mental abuse. And unfortunately, that is incredibly hard to come by. If there are accusations of mental abuse, the court has the option to provide what's called a guardian ad litem, or a GAL, and this person may be appointed as a representative for the child. This is an attorney who acts in the child's best interest and works to ensure the best possible outcome for the child is achieved. Not saying we don't do that, but a lot of times attorneys who are representing mom and dad are looking out for mom and dad's interests as well, and this person is specifically for the child. So this is all information related to abuse in custody factor number 2, and many of these things can be taken into account by the judge, and that's really the backbone. I mean, it's a pretty straightforward factor. So thank you for tuning in to Jurisprudence by Jenn again, and we will be back next week when we address factor number 3. If you have any questions in the meantime, hop on over to our webpage at jdlawpa.com and send us an inquiry. There's a contact page. Or if you need legal advice specific to your case, please call me directly at 412-295-8066 or email me at jennifer@jdlawpa.com. Thanks and have a great afternoon.